custodians.
Can we just confirm that now the recording has just started now?
Oh, okay, thank you. I thought it said it had. Okay, well, we'll start that again. Welcome everybody to today's session, as there's going to be people joining us gradually as we go, and there are people from a range of different sectors, from the legal sector, from the financial counselling sector, from the gamblers help therapeutic sector, and a sprinkling of other different kinds of services. As people join, we'd appreciate it if you keep your microphone muted, obviously, just so that the quality of the sound isn't disturbed, or is as good as we can possibly make it.
And also you can just turn your video off as well, if you'd like to do that.
Yeah. So that voice was Heidi Phillips, our excellent producer, who is going to be helping us manage the technical issues behind the scenes. But before we go any further, I'd obviously want to acknowledge the traditional custodians of the land wherever we are meeting. For me, I'm on Boonwurrung country. For other people, they might be from different places around Victoria, but we acknowledge those traditional custodians and pay our respects to elders past, present and emerging. I would also like to, of course, welcome our illustrious panel. My name is Elena Campbell. I'm Associate Director at the Centre for Innovative Justice, and I'll be moderating the discussion today. But the real stars are our panel of fantastic practitioners, all of whom I've worked with and I can vouch for.
+614289000162 is now joining.
Oh, got a funny sound there, Heidi. I'm not sure what that was. So first of all, we have Sarah Davidson, who is Financial Counsellor employed by the Centre for Innovative Justice over the last year or so, but seconded into the Mental Health Legal Centre. We have Anne Jorgensen, the Principal Lawyer from MHLC. We have Christina Bukak, who is the Lawyer and Coordinator of the Inside Access Program, which is the program that works into Dame Phyllis Frost Centre. And Amanda Carter, who is the Managing Lawyer at Therapeutic Courts, Victoria Legal Aid. What I'll do first, though, before we throw to the panel, is give everybody who is joining us or listening into the recording later a bit of context to how this all really came about. And as we go through, then I will ask our panel members a series of questions, which may in turn answer any questions that you may have along the way. But what we'd like you invite you to do is throw any questions that you do have into the chat function, and we'll be monitoring those. And at the end, I'll come back and look at the chat function and see whether we've addressed your questions throughout, or whether we need to spend some time addressing any gaps and questions that you may have. So that's the way that we can make this as sort of efficient as possible. It also makes sure that we're keeping the sound quality as good as possible, including for the recording. Okay, Heidi, if you could move to the next slide. What I wanted to just give you all a sense of is how this program that we've been running and the session today came about because the Centre for Innovative Justice, which, for those of you who don't know us, we're a fairly distinct reform and research body attached to RMIT University. We all come from a practice and policy background rather than being conventional academics. So we're very interested in doing research which identifies solutions and then working with government departments or courts or wherever it is to actually help implement some of those solutions. And in 2017, we published a report which had been actually commissioned by the Victorian Responsible Gambling Foundation, looking at the intersection of contact with the criminal justice system and gambling, or essentially identifying contact with the criminal justice system as a form of gambling harm. And we found that because of legal precedent and as well as the various attitudes from the judiciary, more generally, lawyers were quite reluctant to raise the issue of gambling behaviour in the mix of the lives of their clients. even though many throughout our research identified that it was indeed a bit of what was often characterised as a sleeper issue in the lives of their clients, even if it didn't directly contribute to their clients offending. But the reason that they were reluctant to raise this issue was because essentially, at its simplest form, courts still tended to view gambling behaviour as of choice rather than as a factor that was beyond the client's control, in the way that courts will often view other forms of addiction. And because of that wasn't going to be an issue that would go towards mitigation of sentence, i.e. making the process less punitive for the clients. So meanwhile, lawyers and judicial officers were all aware that clients were more reluctant to disclose gambling because of the associated stigma that it has, including, which are reflected by those views from the bench. And so it was very, very difficult to bring that issue to the fore. Now, our research, if everyone joining us, when you join, could you just make sure that you're muted? That'd be fantastic. Now, our research identified a range of different pathways. So Heidi, if you could just bring to the next slide now, thanks. A range of different pathways between gambling and offending, and obviously everyone in the community would be relatively aware of what you might call a linear pathway, in which gambling behaviours are the primary driver of offending. And that, of course, can be in the form of quite sort of visible high roller gambling behaviour leaning towards embezzlement, or it could be something relatively low key, like someone gambling a lot on the pokies and embezzling from their local sort of a relatively small business in order to pay that back. Similarly, we found there's a lot of drug related offending directly related to gambling behaviour, and our research analysed their sentencing remarks from over 100 county and Supreme Court cases, which essentially were focused on that particular pathway, that direct and identifiable pathway between gambling and offending. But what we also heard, perhaps just as often, if not more often, was from lawyers and as well as a range of different practitioners working in and around the Magistrates Court jurisdiction, where they were identifying gambling as not necessarily the driving factor, but as a factor that was in the mix in the lives of many of their clients, which in turn was so entrenched and wound into the complexity of their lives that it was very difficult to extract themselves from compounding disadvantage and debt, particularly when people perhaps were then released from prison. So Heidi, if you could move to the next slide, and these slides will be available after the session as well. So what we realised or identified was that across all these different scenarios, including in where gambling behaviour might converge with some other issues like family violence, it's a well recognised that many victim survivors of family violence will sometimes seek respite in gambling behaviour in venues and then develop experience gambling harm and significant gambling problems as a result. But what we found was that the legal system wasn't currently equipped to identify that. And that's partly because lawyers were not necessarily comfortable asking the question about whether their clients had any gambling issues. Also, lawyers were definitely not comfortable raising those issues with the bench if they were aware that their clients did have those gambling problems. And courts are generally pretty terrible at gathering data, so courts didn't really have anything sort of too concrete to establish a case for thinking about, well, is there something more that we can be doing in this area? One exception was the Court Integrated Services Program, KISP, which through case management did identify gambling where it was in the mix in the lives of their clients, and that's because they had those case managers work with clients over a period of a long time and develop a relationship of trust, which sometimes overcomes those issues of stigma that might otherwise not be there. So given that many clients don't identify themselves as having gambling issues, perhaps being the primary issue that they face, or that they feel a significant amount of stigma attached to the disclosure, we were aware that a wider service remit might be required to start to unpack that mix. And with a financial counsellor, potentially a useful entry point to identifying clients' gambling problems and referring them on to longer term assistance. So as a result, we sought funding from the Victorian Responsible Gambling Foundation, who I know are joining us today, to pilot a financial counselling position. And this was designed to work alongside the lawyers and social workers at the Mental Health Legal Centre, with whom we're co-located at the CIJ, and who have an inside access program which works into Dame Phyllis Frost maximum security women's prison. And that was to complement the social work position that we already seconded into that and into that program, and have done so for a few years. So with the support of MHLC and the DPFC program staff, we collaborated to identify a way to go about delivering financial counselling services into the prison. And then obviously juggling the fact that there is limited space and time within the prison. So trying to work out what the best format for that is. And Heidi, if you could just move to one more slide, that'd be great. Thank you. What was fantastic, I have to say, is that DPFC program staff were just highly supportive and indicated that there was a really significant demand for financial
I think
whoever's joining us might need to just mute themselves for thanks. See if I need to send a message to somebody. And what was particularly interesting and significant gap were services for women on remand, who often miss out on services because of the churn through prison environments of all sorts, but particularly through DPFC. So we, in discussions with the other services who are already delivering financial counselling services into the prison, including Good Shepherd and Banyule Community Health, we identified that women on remand were the priority group that we were going to work with. And accordingly, for the last 10 months, Sarah Davidson, with the help establishing this program from Raylene Carney, who's no longer in our organisation, but I think might be joining us today as well, has attended DPFC for a full day every week, which has been fantastic, delivering group-based information sessions in the morning and seeing clients for individual appointments in the afternoon. And obviously the recent COVID impact, which sees us all gathering virtually, has had an impact on service provision into DPFC. But pretty amazingly, the inside access staff have been able to keep going in after a short hiatus, and that includes Sarah delivering some services for a slightly more confined time and some phone-based contact work as well. So over a period of 10 months, there's been a lot of hard work, very rapid project establishment, all of which has been fantastic, and I'll sort of touch a little bit more on that at the end of this session, including where to from here. But you've all joined not to hear from me, you've joined to hear from our panel who want to talk about their direct experience of what this has been like. So Heidi, perhaps if you could put us all just on the screen, and we can lose the PowerPoint now. And we will throw to some of our panel members. And the first is Sarah Davidson, our financial counsellor, who had to do a lot of work in a pretty short space of time to jump into setting up this program alongside our fantastic MHLC colleagues. Sarah, what kind of issue, you've worked in a whole range of different service environments for financial counselling. What kind of issues did you find were coming up for women in DPFC?
I think the first and really most startling thing that came up for me was that they have no way of contacting anybody to tell them about their new circumstance. So it's partly the reason why we think the timing of seeing a financial counsellor is really important in that environment. But the fact that they can't call someone and say, hey, I'm not going to be paying for a while, or I need to make a change to my arrangement, really puts them on the back foot at the very beginning, particularly if they were already in any sort of arrangement of making payment towards debt. They also don't have the ability, obviously, to access their bank accounts either, to move money around, to make it available, to make sure that their financial obligations are met whilst they're on remand. We also saw a really large percentage of women who have their phones seized by the police when they're arrested. And anecdotally, we're told there's very little chance often of that being returned. But in almost 100% of those cases, they are contracted handsets on a plan with a telco provider. And it then becomes a challenge for that individual, because they've suddenly got a phone they're never going to see again, but they've got quite a serious financial obligation that's attached to their phone. We come across the standard sort of stuff as well that you would in generalist financial counselling. There's utility accounts, there's rent arrears, there's debt collectors involved. We have a high level of payday lending because a number of the women we see fall outside of standard lending criteria. And then we have some of the more unusual things, such as people who are at risk now of becoming homeless because they're in a private rental whilst they're incarcerated and they can't pay the rent arrears form, and they're potentially facing homelessness when they're finally released. Or the fact that we're trying to locate their car, which has possibly been impounded, make sure it's registered in a safe space because they intend to go and live in that car when they are released from prison, because that's the safest place for them to be. So often we had ladies attend who are like, I've got an enormous amount of debt. It was overwhelming for them, only to find that they're often old and were already what we would call statute barred, and so couldn't be collected. But because they have no idea of their rights, or they've got no idea that those debts don't need to worry them anymore. But we did have, and I think we looked at possibly a quarter of the women that we saw did have lending done with mainstream lenders, but the 3/4 of the rest fell outside of that mainstream environment.
So what kind of steps can for those of us uninitiated in this, in that kind of practice or discipline, what kind of steps can a financial counsellor take to help clients with those issues? What do results look like in that context?
Well, the first step we're always going to take is ask them what do they want to do and what outcome are they seeking, because it's easy for me to decide what the best outcome is for them. But in reality, it's really what do they want to do? And that can really range from them wanting to put something on hold until they're released and able to re-establish themselves. But given that they're really not aware of what most of their options are, they've generally taken to not answering their phones, ignoring stuff, ignoring emails, and just letting it all pile up in the background. So then the second step is for us to build that picture of what their financial position is when they are not incarcerated, and then outline what some of those options might be for them for their particular situation. Really make sure they're informed around their rights, particularly around debt collection and the age of debt. We give them education about safer alternatives for borrowing money in the future, and we connect them through to other services such as social work, legal, or housing. You touched on what do results look like. Well, they vary depending on the person. So for some people, it's that relief of knowing that someone who they're going to tell their story to this time is actually going to provide them assistance. That there's the possibility sometimes to have a debt waived, particularly if it's incurred through, say, family violence or other circumstances. For some people, just knowing that that debt is no longer enforceable and that payment isn't required is all they needed to hear for them to be able to move forward. And for others, knowing stuff like a credit list, a listing on a credit report sits there for 5 years generally and then disappears is an astounding revelation for some women who thought they were affected forever. So it's really that worry that people have coming into that environment where they don't know what's happening outside anymore, and it's the stress of not being able to manage it and think that it's just going to blow out and be really terrible when they're released. So the biggest result I can tell you I see, it's an actual physical shoulder drop that happens, and anyone in financial counselling who's in this room will have seen that before. It's the shoulder drop when the person realises that the woman or man sitting in front of them can intervene, they can focus on their issues, and they're there to help them.
So what are the challenges in terms of working with clients in this particular context so that you can get them that shoulder drop? What are the sort of solutions for practice in this area? You've had a very specific remit that you had to go in with very quickly and get your head around all sorts of things in a very short space of time. What are some of the solutions going forward that you would see that would meet the challenges you've experienced?
So the challenge that you have in any financial counselling space is the same in the prison space, is meeting demand. The waiting list is enormous, and unfortunately often with the turnover of remand women, it means you don't get to see them and support them before they leave the prison space. And then it's that fact of them leaving with little or no notice whilst we're in the middle of working with them, often with no forwarding address, so we can't provide them always with an update of where we got to or where they should go to next once they had been released. Lots of women report telling their story multiple times and being made promises by service providers that were never seen through. So we've had to really work out how do we, in a very short amount of time, build rapport and establish trust that we're actually going to be able to do what we say we're going to do for them in the very small window that we have. Getting them in the door in the first place, massive challenge, because they don't understand what we do. They don't know what benefit we can provide. And unless we have that, really good, advertising as such in the prison environment, they don't know what they're missing out on until they've actually come to see us. We have a massive challenge with lack of documentation. Once women are incarcerated, they can't access the documents that lots of providers need. We are significantly delayed in seeing them. When they enter the prison, they have to undertake a number of other activities before they're able to engage with us in programs. And some of the lack of compassion that creditors have far-reaching consequences for someone who enters the system. Like, for example, someone could spend a long time on remand. During that time, they lose their children, their job, their house, and all their belongings. They could be released, the charges may be dropped and they're released without any conviction, but it's going to take them a really long time to recover from that moment of their life. Or they are convicted and they are sentenced and they're going to be away for a long time and or no longer eligible to go back to the employment they once had. So it was a real challenge sometimes having those creditors really understand the true consequences of someone being incarcerated. Some of the solutions, though, we do have some. Financial counsellors always have solutions. Ideally, it's part of the orientation when someone enters the prison. Potentially, it would be great to be able to sit within the remand unit at the prison and see women on a drop-in casual basis who are just kind of in that space and not have them have to go somewhere else. Sitting with integrated practice is obviously a really important part of our work. There are some women that I would never have seen had Christina not referred them to me, and the same with Bernice, our social worker. That the correction system really acknowledges the value and benefit of a solid financial counselling program, and that's regular, being given adequate space and adequate ability to educate the women on the value of it. It'd be wonderful to be able to see them outside the prison, even just one time, to help them reintegrate and manage once they're back in their own environment. And of course, that continuing financial literacy and education that we'd like to have women be able to have access to while they're there.
Fantastic. Thanks, Sarah. So Christina, Sarah's just referred to the clients that she got through referrals from you. Christina, you coordinate the Inside Access program, which is a fantastic program. Are the issues that Sarah's described the kinds of issues that you see regularly in your client base?
Yeah, definitely. Most of the clients, I would say, that we're seeing present with multiple issues, and debt seems to be one of those common features. that pops up very often.
So without a financial counsellor, how can lawyers help with these issues?
Okay. Look, we can, and in the past, before Sarah came on board, we have assisted with debt matters in the past on an ad hoc basis, but we are a very busy service, and of course, being lawyers, and that's what we're trained to do, is actually, assist the client in regards to their legal matters. And as I said, being a busy service, we often have to prioritise their legal matters over their debt matters. And another issue also is that there's a lot of running around, which I think Sarah mentioned, because they don't have the papers on them. They may not even know who their service provider was or who the utility provider was, is that there can be a fair bit of running around just trying to get the information before you even get to the point of, potentially coming up with a plan of attack.
So what difference does having a financial counsellor as part of an integrated practice team make?
Oh, I mean, obviously, it makes a huge difference. And I know and you did raise that, yes, DPFC do have a number of financial counselling services, which is great, but definitely the demand outweighs the resources. And in particular, the remand women, I believe, were missing out. Many women often will only be there for a couple of weeks. By the time, as Sarah said, they've gone through the orientation, by the time they've put their referrals in and an appointment can be scheduled due to a wait list, they've already left. And so they've missed the opportunity of being assisted. So it's made, a big difference.
Fantastic. Are there any challenges that you encountered in making this kind of practice work in what you've identified as a pretty fast-paced environment?
Look, it is. I mean, initially, as I think with any integrating any new service within a program, is just establishing it and understanding how does it all fit together. So in the beginning, there were those conversations in regards to what does everyone do? So, and we hadn't, even though we had social work, so we were used to working as an integrated practice, but we had not had a financial counsellor as part of our program. And so in the beginning, there was, I think, learning going on, so understanding what can a financial counsellor assist with, what are the matters best placed with them, and vice versa. For example, sort of two debts, common debts that lawyers assist with would be Centrelink debts and fines, and we were able to identify and agree that they were best left placed with the lawyers. And so if Sarah met a client who had a Centrelink debt and fines debt, she'd be able to then refer that to me.
Great, thank you. Anne, as principal lawyer of MHLC, one of the things that we're very keen to do as a result of this pilot is share what we've learned and encourage other CLCs to consider embracing a financial counsellor as part of an integrated practice. Christine has identified a couple of the challenges early on in the establishment. What more broadly for legal practices considering involving a financial counsellor, what are some of the things that should be considered to be able to prepare for upfront?
Yep. Well, I think obviously right at the very outset, being clear about the context that you're working in and how financial counselling is going to fit into that in terms of who the stakeholders are, who the other service providers are in the space, as Christina and Sarah both talked about. And what are the practical constraints of delivering? I mean, prison obviously has some very specific issues, but I think they're important to investigate in terms of any new program that you're looking at developing. Christina spoke very clearly about the issue in terms of identifying who does what. And I think that was, I'd referred to financial counsellors throughout my career, but until we were working alongside Sarah, I didn't really appreciate the scope of what they could do. So identifying where that scope kind of overlapped, which I think it does more so with financial counsellors and lawyers than perhaps with social workers and lawyers. Like there's more issues that you kind of could come at from either either profession. So how we identified that and where things would go, and then obviously referral pathways, because our clients never just come with one discrete issue for us to neatly manage. Then I guess as principal solicitor, then I have all the boring stuff to look at, which is, you know, and all community legal centres are required to work within our risk management guide, which is closely tied for many centres into their professional indemnity insurance. But for all of us, it's, I guess, a binding document that sets mandatory standards around a whole lot of exciting things like supervision, document management, file destruction, all those kind of things. And that guide's really clear that it doesn't just apply to lawyers, it applies to all aspects of the practice. So, for example, there's an obligation on me as the responsible person to have some kind of supervision, in the words of the thing, of the practice of employed non-legal caseworkers, which in this case, with Sarah being such an experienced financial counsellor, wasn't a burden, but perhaps if you were, you know, bringing on board a more junior financial counsellor, that would be something to factor into the resourcing of your program. And yeah, I think that idea, you know, integrated practice is not just about the client-facing end of it, but it's also about the back end too, and how we integrate the different types of practice. And so we spent time in the beginning as, you know, aligning our intake sheets, our open letters, our closed letters, how we managed files to make sure that they met, obviously already met Sarah's professional obligations, but also met our obligations under our risk management guide and all those things that trip community legal centres up in their annual cross-check of having limitation dates checked off, conflict check, that kind of thing. So I think just working out how to kind of embed it in the documents that we work within.
Great. Thanks. Just before we continue, just a reminder to everyone to mute their mics if you're, just because there's a bit of background noise somewhere. But we will press on. And what about that really, as well as all of those really important back-end issues, what about some of those thorny disciplinary issues, like the difference between legal professional privilege and what some other practitioners, the obligations that some other practitioners might have? How do you manage those things, particularly where there is an intersection of the issues that financial counsellors and lawyers might need to address, as you've identified?
Yeah, I mean, I think they're kind of different issues raised with financial counselling. It feels quite distinct to the sort of things that we deal with, say, when we have the social work kind of overlay. And I think because often what financial is something that a lawyer we could take on if we kind of were so minded. I think the main thing is just, I guess, being clear around, you know, the supervision model, how we check on things. We run separate files in our integrated practice for social workers, financial counsellors, and lawyers. So we don't tend to manage a client altogether. So it's pretty distinct, sort of who they're dealing with, and those things are kept fairly separate.
But for financial counsellors listening who might not have an experience working in a legal practice, what does legal professional practice or privilege look like, and what are the sort of considerations that financial counsellors coming into a practice might need to bear in mind?
Yeah, well, I guess it's an overarching obligation that lawyers have around information that's gathered for the purpose of legal practice. And it's kind of one of those, I guess, fundamental obligations that lawyers have in relation to their work. And it's important for us as lawyers to be very careful about how we manage client information so that we don't give up that privilege that exists over clients' information and what they have. It tends to be, I mean, it's often an issue, I think, when you're integrating social work and legal practice because of the types of issues that get disclosed in in a social work setting that could really be quite problematic if they came out in a legal proceeding. I guess I haven't seen it as being as much of an issue with financial counselling, because it tends to be, I don't know, less kind of less fraught issues, I think, in terms of the types of matters that we see.
Yeah. Okay, thanks. And one, just finally, is gambling an issue that, because I know a lot of people have joined us to hear about the gambling aspect. Is gambling an issue that you and Christina identify as coming up often in your client base? And if not, why not?
Yeah, well, we certainly see it. It's probably not at the forefront of what we see and what we do. A couple of years ago at the prison, we ran a bulk debt negotiation project, and we asked people as part of the intake for that if in sort of the list of other things that whether problem gambling was an issue, and a bit under 40% of the women did say that it was. In terms of both within the DPFC work that we do and in our broader practice at the Legal Centre, we do on occasion see situations where it's very much tied to the legal problem. We don't have a criminal law practice. We only do quite low-level criminal matters, but we certainly, I guess, see it as part of a bigger picture of issues that a client has. But I think, as you identified in the opening, it's often a very relevant part of a person's circumstances and how they've got into the situation they're in, but it's often not that helpful to resolving the legal issue that they have. And so, a lot of the work that we do with fines, say, or Centrelink debt, we might see how gambling is relevant, but it's not, it's not part of the special circumstances for having a fine waived, for example. It's not part of what Centrelink will necessarily look at in considering whether special circumstances apply there too. So I think there is still a different approach to it. So that I think, as you identified, as lawyers, we're still kind of nervous about how we disclose that. And when we did our bulk debt negotiation, while it was information we collected, it wasn't part of what I put forward to the creditors to encourage them to waive women's debt. And I don't know, how much is that my own, not giving people the opportunity to reflect on it further, or is it a realistic that it's not faced with as much of a sympathetic approach? So
certainly what we heard in our research is that it's a bit of a lottery as to whether clients will be faced with a sympathetic approach.
Yeah.
But on that note, we've also got, importantly, Amanda Carter from VLA here, who is the managing lawyer for therapeutic courts and has an eye to this issue more broadly across magistrates' courts practices and other things. Amanda, VLA have obviously recognised the benefits of integrating financial counselling and legal practice, because you have a new pilot being established in relation with Good Shepherd. Can you tell us a little bit about that?
Sure. The 2-year pilot's being run by our family law program, and it involves a financial counsellor from Good Shepherd co-located with VLA's family law and child support teams in Melbourne 1 day a week. The pilot service provides access to financial counselling at an early stage after separation to help clients, including women fleeing family violence, to deal with debt and promote their financial security and the well-being of their children. Integrating financial counselling with the lawyers means there's a better opportunity to deal with the financial issues early before they compound to something that's much harder to recover from. And having support to deal with their finances can help clients worry less about financial problems and allows them to focus more on addressing their legal and other issues.
And what about the prison helpline for clients with that particular cohort? Would referrals to financial counsellors through that program be an option?
The Prisoner Legal Help Service does refer to financial counsellors where a debt or financial issue is raised by the client, but one of the limitations is that outgoing phone calls by prisoners are limited to 12 minutes. So where gambling or financial issues are not the main presenting issue but are among problems people are dealing with, it's difficult to explore that within that time frame. Prisoners can call back another time, but often they can't do it straight away because of the demand for phone calls in the prison. So it doesn't really support disclosures about gambling or financial problems that might be co-occurring with legal issues. Within these constraints, financial and gambling issues are not currently frequently identified in our Prisoner Legal Help Service. It's more likely to be our practice area lawyers or perhaps our legal help lawyers advising clients who are not in custody, who have greater time and opportunity to get to other issues that are in the mix for clients beyond their main legal issue. But I think that all lawyers would benefit from guidance as to how best to ask the questions that might unpack this issue and link clients in with supports.
Mm. And as you identify, it's a question of how best to ask the questions. Is that because of a sort of anxiety around, is that because of lack of time or because of a sense that this will divert the conversation with the client in a new direction and potentially an unhelpful direction? Is it difficult? Is it a difficult question to ask?
I think that lawyers don't routinely ask clients about problem gambling unless it's raised by the client themselves or by the circumstances of their legal matter. And that might be because lawyers are unaware of how prevalent it is as an issue for clients, and it's not front of mind in the same way that drug or alcohol use or mental health issues are. I don't think it's really, in reality, more difficult than asking about those questions, but I think sometimes it can feel a bit intrusive unless we're clear about why we want to know and what we're going to do. And it also depends on context. So how much time we have to spend with clients. And yes, lawyers would be less likely to ask in a busy duty lawyer list pressed for time. And yeah, it certainly is that issue around it might well be difficult for clients to disclose, given we know there's stigma around this issue. So training on how best to ask in a way that's more likely to make the client feel comfortable to talk about it would be helpful.
And is that sort of just one of the reforms that are needed in this area?
Yeah. I mean, certainly VLA wants to see a criminal justice system that responds to people's needs and does not cause harm, and contact with the justice system is an opportunity for positive intervention and to support people to start to deal with problem gambling, regardless of whether it's the main issue that's brought them to court. So yes, training for lawyers and court stakeholders on the prevalence of the problem, how best to draw out those underlying issues, and on the neuroscience of gambling addiction. Improved data collection is needed across the system also. And while there are quality gambling services available, there isn't a specific program into which people in the criminal justice system can be referred. So development of a robust therapeutic model and pathway for a program by gambling support services would be really useful. And that could potentially incorporate also restorative justice approaches that may well be suitable, particularly in circumstances such as theft from an employer, where the thefts occurred to fund a gambling addiction, for example. And there's been reference already to the potential benefits around co-location of gambling counsellors, whether that's at magistrates' courts or as part of the Court Integrated Services Program, or indeed at a VLA office.
Thanks, Amanda. It's just strange how great minds think alike, isn't it? Back to Sarah. what we wanted to know, sort of zeroing in again on the practice, on the pilot that we've just run for the last 10 months, where did gambling feature in the equation for the clients that you've seen at DPFC?
So initially for us, it was really quite difficult to identify the presence of gambling with the women that we were seeing. What we did is made an action, and that included then adding gambling to other areas that we would consider special circumstance, such as mental health, AOD, homelessness and family violence. And we also expanded the question out to include affected others, such as family members. By reframing the question, we found more women identified gambling harm, and we were then able to ask further questions about whether the gambling was linked to their incarceration.
So once you'd sort of done that reframing and women were feeling a bit more comfortable and confident, what was the percentage of clients who had experienced gambling harm, and what did you do in response when they identified that?
I guess the final percentage we found affected sat around 40% of everyone that we saw. Once we ascertained whether or not gambling harm was in their sphere, we added further questions around whether it was the woman herself, and if so, whether she had or was seeking to have any assistance in managing that behaviour. If the response was positive, we would make the referral through to therapeutic counselling, and that could either be internal at DPFC, where there is a Gamblers Help funded therapeutic counsellor, or to an external Gamblers Help agency.
Okay. And as a financial counsellor, what have you learned about the intersection of gambling and offending, which you might not have considered before?
Offenders have really complex issues, and we know that gambling can be just one of a whole gamut of things that are going on. Many of the women we met came from really disadvantaged backgrounds, and they'd had exposure to or had been influenced by so many issues for a big percentage of their lives, of which gambling just became one, but of which with all their issues together made them really vulnerable to be exposed to that. When I asked women, has the gambling contributed to your incarceration, apart from them most of them having a little chuckle and going, of course it was, most responses were around, it's all a vicious cycle and the gambling is just one bit. And I guess I hadn't considered that someone would feel sometimes that their only option might be to offend, either because them or a significant other had actually gambled. It's not something I'd ever really given much thought to before. And I heard lots of times from women, if me or my partner hadn't spent all our money at the pokies or wherever it was they did their gambling, then I would have had enough money to purchase the drugs I wanted, and then I wouldn't have had to do whatever activity it was that resulted in their offending. So once we kind of destigmatised and we stopped calling gambling like its own specific issue, and we actually reframed it as a circumstance, more women were really a lot more open around talking about it and how it might have affected other parts of their lives that in their case potentially led then to contribute to their offending.
And that's a really significant shift, isn't it, in terms of reframing the issue as a circumstance rather than something associated with stigma, or as we found in our research, many courts still view associated with a sense of choice and therefore a level of moral culpability that is not attached to the other kinds of co-occurring issues that you will have seen throughout, whether it be AOD or mental health.
And I also think, gambling is really accepted in Australian culture. It brings really good revenue in, and it really, I think, prevents people acknowledging the harm that it causes. And so I know even just from a financial counselling perspective, and I work in a gambling interest working group with other financial counsellors, we all acknowledge that we need a far greater acknowledgement that gambling is an addiction, and it causes a great deal of harm, often in the same ways that alcohol and drugs can cause harm, and it needs to be taken seriously as those other addictions in what the outcomes can be for people, not just incarcerated people, but for, for everybody.
Fantastic. And thank you. We've started to get some questions from the audience, and we've just got a little bit of time left for that, so we've timed it very well, actually. And a question from Sandy Ross. Thanks for joining us from the Peak Body. A question for Sarah. How do you manage the terrain around empowering self-advocacy versus undertaking advocacy on behalf of clients in the prison setting? And where are the significant barriers for clients to self-advocate?
It's a really good question, Sandy, because I talk about financial counselling in a prison environment to be very different to generalist financial counselling, because as you've pointed out, self-advocacy is going to be a challenge for someone who is serving a custodial sentence or who's going to be in custody for quite some time. So initially, a lot of the work becomes the financial counsellor being the advocate for them. And in my experience with some of the women we saw, us getting a result and walking the woman through the process and explaining what their rights are and how we got that, we will hope that they can apply that when they are in that situation, potentially next time if it happens externally. But it's also why we would really like the opportunity to be able to see women after they've left custody, because I think that's a key moment, is you can rectify someone's issues for them while they're in prison, and you can do as many debt waivers and everything as you like. But if they repeat the same behaviours and patterns once they're released, we've really done nothing for them in relation to empowerment and helping these people moving forward. So the ability to provide some post incarceration support is really, I think, where there's a really big hole.
Fantastic. And there's a follow-up question along those lines, that do you refer to a local Gamblers Help service when people leave prison?
Yes, so that's a really good question, Kelly, and we do. We knew exactly where the Gamblers Help funded counsellors were. We would try to establish where people's release address was going to be, so that we kind of knew what area they were in, and then we were able to, and we'd write down for them the information of their local one, or we had brochures and flyers that we were able to hand out to people. We also made sure that everybody had a flyer for the National Debt Helpline. So if everything else failed and they didn't remember anything else and they got into trouble, they knew they could call a 1-800 number and they could say, I need some help with my financial matters. And if they mentioned gambling at that point, they could be referred to the right place as well.
Okay, and a question that I'll throw to the lawyers on the panel, and whoever wants to jump in first do so. Is there a role for this is an interesting one from Mark Tregoning. Is there a role for legal education for problem gamblers or people experiencing gambling harm who have not yet entered the criminal justice system to help prevent likely legal problems in the future? Or is that a challenging one?
I think there's lots of roles always for legal education. I think, yeah, in terms of, I think it would have to be, I guess, an integrated approach to work out how to identify those problem gamblers that might benefit from some kind of outreach, community legal education. I'm trying to think of the sort of things that you might cover in that, other than just, a warning, like this is where this might end. But in terms of what you could give as a practical kind of training, I'm not sure. I'm not sure if you've got some more ideas, Amanda, in terms of what would be beneficial for people.
VLA certainly do a lot of community legal education. Is this something that you consider in the context of that, Amanda?
I certainly think it's a good idea for us to consider how we can reach people earlier, because we know these problems snowball and just become more and more difficult. Mark, who's posed the questions from our legal education team. So no doubt he and I can think further on it.
That was a Dorothy Dixer then.
I think for a lot of people, and it's not just individuals, but it's often the people that work with them, is being able to recognise when something is a legal issue. And we can often step in and help, not through different programs and different community legal centres, but often by the time someone's thought to bring in a lawyer or to refer to legal aid or a community legal centre, something's got more complicated perhaps than it needed to be if people recognise the legal issue early. So I think there's something for all of us to think about how we upskill not just financial counsellors, but also people that are more on the coalface of working with people to recognise how to get a lawyer in early within a matter to kind of avert a more complex legal problem down the track.
Yeah. And just as one last question from Charlie Watson, is there a type of problem gambling that stands out? This is a two-part question. And are there plans to use our work to advocate for gambling reform? So I'll ask the practitioners on the panel, is there a particular type of gambling behaviour that you see perhaps more than often? Sarah, was there anything that clients described, or was it more just the harm that they experienced from that behaviour?
Most gamblers that I came across were pokies participants, and even just standing in the programs room. So most recently when I was there was a woman sitting on a couch waiting for an appointment who was going, "Oh, I'm so glad that I'm incarcerated while the pokies are shut, because I don't know what I'd do if I couldn't go. Okay, I hope they're open before I get released." And so that tends to be the gambling habit of choice for most of the women that I saw. But I also, didn't see it in any particular pocket any different. And whether or not it was a woman who may be incarcerated because she had committed a fraudulent act against an employer, or if it was someone that, was doing something else to fund their gambling habit, it didn't seem to affect, what socioeconomic background they came from, how old they were, what suburb they lived in. It just tended to be a problem.
Certainly, broader research indicates that pokies or EGMs have not only very high prevalence or uptake, but also a significant amount of harm associated with that. But in terms of the second part of the question, certainly we as CIJ, we always advocate for all sorts of reform, and one of the things that we're doing now is working with Victoria Legal Aid and in collaboration with the Victorian Responsible Gambling Foundation to look at what interactions or positive interventions for people coming into contact with the criminal justice system more widely, even at risk of coming into contact with the criminal justice system, which I suppose goes to that question of, is there a way in to intervene with people before they might have a criminal justice problem, but they might have a family law problem, or they might have some sort of other civil legal issue. We're exploring opportunities to do that. But we've reached the end of our session. But on that note, I would just like to thank everybody for joining us, and also thank you to our fantastic panel who have taken time out of their busy practice lives to join us today. I also wanted to thank the Victorian Responsible Gambling Foundation, of course, because they resourced and supported this program that Sarah has been working in, and it's been a fantastic result because with the support of MHLC, of course, we've been able to prove its value, and I think MHLC are going to pick that up and run with it without necessarily saying too much on their behalf, which is really encouraging to see. So we always look to opportunities to identify ways in which the legal system in whatever its manifestation can function as a positive intervention in people's lives, and we really believe that this has been one of those ways. So thank you all very much for joining us, and we'll have the recording of this webinar available relatively soon for people to distribute, and a few other resources as well. So thanks very much for your time, everybody.
Thanks, Elena.
Thank you.
Bye, everyone.